Hi everyone, welcome back to my channel. Thank you so much for stopping by. For those of you who are new to my channel, I'm a lawyer and I've previously made a video that was loosely based on Dahvie Vanity and the difficulty that exists with placing sexual predators behind bars. This video is an extension of that, so if you haven't watched that video, I do recommend that you do, just so you understand the context of this video. I'm making this video for two reasons. Firstly, to clear up a very common misconception that is attributed to social media receipts. In my last video regarding this topic, I did receive a few comments telling me that there is a lot of evidence that exists against Dahvie Vanity, and unfortunately I think people have misunderstood my message in that video. I wasn't saying that there isn't any evidence. There is an overwhelming amount of evidence. However, I do want to clarify that receipts, as people like to call them outside of the legal realm, are evidence in the court of public opinion. When it comes to a court of law, they can only be admitted if the author of these statements is also involved as a witness who can testify as to the contents of these social media messages. So, for example, in Jeffree Star's case with Dahvie Vanity, the screenshots of his tweets where years ago he alleges that he witnessed Dahvie Vanity do illegal things with a minor, those screenshots by themselves are not admissible into court as evidence because they are hearsay. Hearsay is generally inadmissible unless it falls under a number of exceptions. Now, I'm not going to go into detail about what these exceptions are because evidence law is an entire subject in law school, and this is not the purpose of this video, obviously. But I do want to say that in order for Jeffree's tweets, for example, to be admitted as evidence in a court of law, Jeffree must be willing to come forward as a witness and to provide testimony with regards to those tweets that he made. If Dahvie Vanity's case were to go to court, for example, Jeffree can then be examined and cross-examined on the contents of his tweets to ascertain whether they are true, to poke holes in his statement, for example, basically to paint a picture for the jury in order to help them decide whether these tweets were factual statements or not. If you were to introduce social media evidence without the people who made these statements as witnesses, there is no way to find out whether these statements by themselves are factual or not. I'm not saying that whatever someone says on social media is automatically false unless you can prove that it's true, but when it comes to evidentiary rules that we are bound by in the legal system, that is the way things work. And I know it's frustrating for people who are not aware of these rules to hear this, because I was once not a lawyer. I wasn't born a lawyer. And I was just like you, especially when a lot of people are coming forward saying the same things. The more people are alleging a certain thing happened, the more likely it is that it's true, right? That's how logic works, especially when these people aren't related to each other and they're talking about events that happened in isolation, so at separate times. So I get it. In my last video, people think that I don't believe the social media statements. I'm not saying that. I'm trying to clarify to you why that man and millions of others like him are not charged with a crime and are not behind bars. Evidentiary rules exist for a reason. It's to make sure that, number one, a defendant is given a fair trial and that no innocent person is wrongly convicted, which is known as a miscarriage of justice. So to prevent a miscarriage of justice. And another reason is to ensure that the court process is as efficient and smooth and straightforward as possible. So I hope that helps you understand why social media evidence is inadmissible or is very weak evidence without the author of the statement making themselves available as a witness to back up what they wrote on social media. Because don't forget, if you've watched my first video, which again you should if you didn't, because I do explain this in detail, the jury must be convinced beyond a reasonable doubt that a criminal committed the crime that they are charged with. It's a very high threshold to meet. The second point I wanted to talk about in this video is the importance of witness testimony when it comes to proving certain crimes, especially crimes that are committed in private, such as sexual crimes. Now, again, I talk about this in more detail in my first video, but what I didn't talk about is the number of witnesses out there, or potential witnesses rather, who are unwilling to involve themselves in a case purely because they are scared, I suppose, or they might have the mentality of, this has nothing to do with me, I don't want to involve myself in this headache, I don't want to inconvenience myself. Unfortunately, this is a very real problem, and as a lawyer, I have witnessed cases completely fall flat on their face simply because key witnesses refuse to involve themselves. And I'm talking about cases where there were social media receipts, by the way, screenshots of a witness talking about the crime that they've witnessed. But because they refused to involve themselves, and because the police didn't consider the crime to be serious enough to issue a subpoena and force the witnesses to testify, the prosecution lost the case and the victim was left with no sense of justice. Now, I do want to mention that I'm only talking about more serious cases in this video. I'm not talking about petty crime. So if you've witnessed someone run a red light and you don't want to involve yourself and inconvenience yourself, that's fine. It's someone running a red light. It's not that serious. I'm talking about cases where your testimony or your evidence could potentially either save someone's life by making sure that this person is put behind bars so that they could never harm another living soul again. So I'm talking obviously murder, but I'm also talking sexual assault, any form of assault, arson, a robbery, serious cases that justify the inconvenience of involving yourself by providing evidence. So if you're out there and let's say you're a potential witness, you're sitting on some information that you have not volunteered to the authorities, ask yourself two questions. First of all, is the crime serious enough to warrant my involvement? And second of all, do I have evidence in my possession, or have I seen something that can potentially help resolve this case? Now, most people who have not had experience working in the legal profession do not have an understanding of what is relevant or irrelevant to a case. So if in doubt, my suggestion is to offer your evidence anyway and leave it to the authorities to decide whether they want to use it or not. You're not losing anything by offering it up, but you may be helping someone or saving someone's life by offering the evidence. I also want to quickly make a distinction between direct and indirect evidence. Direct evidence is when you have directly witnessed the commission of a crime. For example, if Jeffree had directly witnessed Dahvie Vanity sexually assaulting a minor. Indirect evidence is when you infer that something has happened based on things that you've seen or heard. Let's say Jeffree was standing outside Dahvie's hotel room, or he was walking by and he heard a girl inside screaming, "No, stop, I don't want to, leave me alone, get off me." Jeffree didn't witness it, but he heard it, and he can make an inference that something untoward or illegal was going on behind that door. Both types of evidence are just as strong and reliable as each other. I know that a lot of people seem to think that direct evidence is stronger and more reliable than circumstantial evidence, but that is not necessarily the case. DNA evidence, which is one of the strongest forms of evidence that we can have, is a form of circumstantial evidence, not direct. Direct is always something that has been directly witnessed by someone. So don't make the mistake of assuming that circumstantial evidence is weak evidence. And the reason I'm telling you this is just because you haven't directly witnessed something, you may have heard something, you may have overheard the witness complain, you may have overheard the perpetrator, the criminal, boast about what they've done. Whatever it is, you can still offer it as evidence that could potentially be helpful to resolve a case. If a jury member heard from you that you overheard the criminal boasting about what they've done, that's going to help them arrive at a decision that the criminal is guilty beyond a reasonable doubt. or if the victim complained to you, that also is very strong evidence that can help a jury arrive at a decision. And the prosecution takes all of this evidence into account before taking a case to trial. Do they have enough evidence to prove beyond a reasonable doubt that the perpetrator committed the crime? That's what it comes down to ultimately. And the more evidence the prosecution has, even if it's all circumstantial and nothing that was directly witnessed by someone, when you add all that evidence up together, it has incredibly high probative value, which means it's very strong evidence. I've talked about how there were cases that completely fell flat and were lost because of a witness's refusal to cooperate. There are also cases, such as Dahvie Vanity's case, that can't even go to trial because of a witness's refusal to involve themselves. On the topic of inconvenience, a lot of people may be thinking, well, why should I involve myself and get a lawyer and spend so much money by going to court and missing out on work, etc., etc. As a general rule, witnesses don't need a lawyer. If as a witness you want to put yourself at ease and make sure that you're covered on all bases, you can get a lawyer and they can advise you on the evidence that you wish to provide and the ramifications of providing that evidence if there are any. And also in terms of expenses, for example, traveling expenses to and from court or missing out on work, you're actually paid a certain amount of money by the party that you are testifying for. And the amount varies from jurisdiction to jurisdiction. Where I live, it's around $500 a day, but it's not like you're out of pocket. You're paid to provide your testimony. So to conclude this video, the entire message is, if you are a potential witness, meaning you have evidence or you are sitting on evidence that could potentially be useful to a case, and you just simply refuse to involve yourself because of the inconvenience that you could experience, just remember that we don't live in a bubble. As much as we live in a society that is growing more and more individualistic and self-serving and all that matters is myself, I don't care what anyone else goes through, that's just not the reality. There's always a domino effect. We're always affected by each other's decisions and actions. I'm not saying it's wrong to think about yourself and to put your interests first, but when it comes to serious situations, that's when the balancing act applies. The balancing act really comes down to, is my self-interest worth more than helping justice be served? Because justice is rarely served. Even if you put someone behind bars, you can never undo the crime. But there is still some sense of closure and justice that a victim or a victim's family members and loved ones can feel when a perpetrator is made to face the consequences of their actions. There is nothing worse than watching a criminal walk free, when you know deep down that they committed the crime, but there was just not enough evidence to prove it. And I've seen it happen. It's gut-wrenching. It makes you want to be physically ill. Just bear in mind that it's about the bigger picture sometimes. The more serious the case, the less it is about you and your self-interest. If you're in a Jeffree Star position, because honestly, I don't know whether Jeffree's lying or not when he says, I didn't really see anything, because it does make me question, why did you say you saw something all those years ago and then backtrack now? I know he explains and says he used the wrong words in the tweet and it was an unfortunate mistake, but to me, I do question whether that's true or not. Today you're a witness, tomorrow you might be the victim. And you might be the one who is in need of witnesses to come out and support your claims, because as I said in my first video about this topic, a victim's words are rarely enough, and it's tragic and it's wrong, but it's reality. That's it for this video. I hope you learned something. I hope I've planted a seed in your mind that you will consider if ever you are involved in a case or if ever you have witnessed something wrong. I hope that this will encourage you in helping out a victim and ensuring that justice is served, because believe it or not, one person's evidence could be the difference between a criminal walking free or facing the music for what they've done. Let me know down in the comments what you think. Please don't mistake my explanation of the law as my personal opinion, because obviously when it comes to a case like Dahvie Vanity, I believe he is guilty. In my last video, people mistook my objective legal explanation as a disbelief of the allegations. I believe the victims. So please make no mistake about that. Thank you so much for watching. Stay safe, and I will catch you in a future video.